The goal of this video is to give people participating in mediation at the Environmental Commission a better idea of what to expect and what is expected of them. The aim is to help such persons to be better prepared for actively participating in the mediation process. This will help to ensure that they are given the best opportunity to represent their point of view in mediation sessions and assist the parties in arriving at a mutually acceptable resolution. Remember that this video is for information purposes only and is merely a guide. It is strongly advised to seek legal advice when possible. The Environmental Management Act, Section 84, Subsection 3, mandates the Environmental Commission to encourage and promote alternative dispute resolution, being any mechanism for resolving disputes other than by way of litigation. Mediation has been identified by the Commission as the alternative dispute resolution process that is most appropriate in many of the cases falling within the court's jurisdiction. Thus, while the court can consider any and all types of alternative dispute resolution processes, mediation is currently the preferred form. Mediation is a method of resolving a dispute between two or more parties through the intervention of an impartial third party, the mediator. The mediator does not function as a judge of the issues between the parties. Instead, he or she is a neutral third party who assists the parties by controlling the negotiation process, but who has no decision-making authority. The decision-making power lies entirely in the hands of the parties to the dispute. The objective of mediation is to assist the parties to voluntarily collaborate to reach a mutually acceptable resolution through dialogue controlled by the mediator. Mediation can thus present an opportunity for savings in cost and time as compared to litigation. At the Environmental Commission, mediation is usually conducted by a member of the Commission. When addressing the member, you should therefore refer to him or her as Your Honor. In accordance with his role of impartially helping the parties through the negotiation process, a mediator will not provide legal advice or counsel to any party. Mediators assist the parties in generating options for settlement and act as agents of reality for the parties, drawing their attention to unrealistic expectations and encouraging alternative perspectives. There are some important points you should bear in mind in deciding whether mediation is a viable option for settling your dispute. Even though the court may refer parties to mediation, the litigation and mediation processes are separate. Nothing that takes place in mediation will be communicated by the mediator to the judges conducting the trial of the case or to anyone else. This includes anything discussed in mediation or any documents submitted to the mediator by any of the parties. The mediator has a duty of confidentiality, and it is the confidential nature of the proceedings that makes mediation work. The mediator will only inform the court that the mediation has been concluded. It is up to the parties to inform the court of the terms of any agreement arrived at in mediation. Because of the confidential nature of mediation, nothing that is said in mediation and none of the documents provided by any of the parties will form a part of the records of the court. Any documents provided to the mediator will be returned to you when the mediation is completed. Similarly, the mediator will destroy any notes taken during the proceedings once mediation has come to an end. Mediation may not be appropriate in all cases or may only be useful in resolving some of the issues between the parties. For example, issues of law cannot be determined by the parties in mediation and can only be determined by the court. Mediation can, however, still speed up the process of litigation by reducing the number of issues for the court to decide. This can lead to savings in time and money for the parties. If mediation is unsuccessful at resolving any or all of the issues, those remaining will be resolved by litigation. You should be aware that being referred to mediation does not automatically suspend the litigation proceedings. It is important to still comply with all instructions given by the court, including timelines set by the court in the Environmental Commission's Rules of Practice and Procedure or in the relevant legislation. To access the mediation services of the Commission, there must be an ongoing matter before the court. That is, an appeal or application must have been commenced by one of the parties, and that matter must not have ended. Mediation may be a useful alternative at any point before litigation is concluded. Thus, at any time before the matter has ended, the parties may apply to the Commission for referral to mediation. Similarly, at any time after the matter is commenced, the court can invite the parties to consider mediation. Mediation is only possible if all parties to the dispute are willing to participate. Thus, before you apply to the court for referral to mediation, all other parties to the dispute must agree. Parties can then apply to the court either orally during a court hearing or in writing by sending a joint letter to the Commission addressed to the registrar. If the court refers the parties to mediation during a court hearing, then the presiding member will usually indicate when and where the first mediation session will be held. The Commission will also usually send the parties a written order of the court setting out the date, time, and location of the first mediation session. Similarly, where at any time after the commencement of the proceedings the parties have written to the court asking to be referred to mediation, the court will issue a written notice specifying the date, time, and location of the mediation session. At each mediation session, the parties and the mediator will discuss and agree to the date, time, and location of the next mediation session. If in between sessions the mediation has to be rescheduled, the mediator will either communicate with the parties directly or through the registry of the Commission. If necessary, the registry will issue a written notice setting out the new date, time, and location of the mediation session. You should plan to arrive in good time for your mediation session. If, however, for some unforeseen reason you are going to be late, you should inform the mediator and the other parties as early in advance as possible. If you cannot contact them, you should call the registry of the Commission. Be aware of the parking situation. The Environmental Commission does not at this time have parking facilities for attorneys or persons attending court or mediation. You should take into account that security procedures at the court may take some time. You should not bring children to your mediation session unless they are a necessary part of your case. In any event, you should consult the mediator before doing so. The Commission does not offer any childcare facilities while you are in mediation.